Yes, ma'am. Good morning.
Good morning, Your Honors. May it please the Court. My name is Rebecca Rose, and I represent the appellant, Mr. Roby. Your Honors, the trial judge in this matter misinterpreted and misapplied the first complaint doctrine, and he erroneously allowed layer upon layer of first complaint evidence in this trial, which resulted in an unfair trial for Mr.
How
Roby.
old were these girls?
At the time of the complaints, they were, during the time period, the youngest one was 7 and 8 years old, and the older one was 10 and 11 years old. At the time of this trial, they were considerably older. I believe the youngest one was 14 and the older one was 18 or 19.
Well, what about their tender years as kind of an exception to our general rule?
Well, I think the King Doctrine says that the first complaint means first complaint. And in this case, in fact, the judge determined that these girls couldn't, their complaints to each other didn't count, yet he allowed them at trial. So if he had said, I'm going to do a substitution because I believe that these girls were too young or they're not competent to testify or there's a particular reason that they could not be considered as each other's first complaint, then it would have been appropriate for the mother to be the first complaint witness.
So you're not saying, I thought in your initial brief that it's just that. It would have been okay if the mother had testified and they had not testified to their telling each other.
Yes,
and then it seemed as though it sort of changed. But
well, with the problem, in the motion in limine, they decided, the Commonwealth said, we think the mother is the first complaint witness, that she was the first complaint to. The judge said, I agree, I don't think these girls are first, they can serve as each other's first complaint. But then at the trial, the girls were allowed to testify that they told the other girl, and the first one said, the youngest said, I told my sister, and she said, me too.
Right, but so that's what you're. I was a little confused by your reply brief.
I'm sorry, Your Honor. That's the first problem with the first complaint, is that these girls were allowed to testify to their first complaints to each other, and then they were allowed to testify to their complaint to their mother, and then later on they were allowed to testify that their grandmother also heard about the pictures on the computer, both of them. And then the older girl, even later in the trial, was allowed to testify that she also told a victim witness advocate and the prosecutor. So now we actually have a string. We have a parade of first complaint witnesses.
So it would have been, if it had just been the mother's the first complaint witness, each girl can talk about telling the mother, I take it.
Right.
But not about telling each other and then not about the subsequent people.
Correct. That's my understanding of the doctrine announced in King. That, and in fact, and Stukich also says that once the first complaint is identified, that's the end of the matter. And in this case, this case boiled down to the credibility of these two girls. There was no other evidence of the criminal activity except what these two girls testified to. And that's exactly, so this kind of parade, these layers of first complaint testimony, each one of them bolsters her credibility, as the case law supports. And what's particularly damaging here, when the girls were allowed to testify that they told each other, that I told my sister and she said me too, and they were both allowed to say that, since the judge did not consider this to be first complaint testimony, he did not give a limiting instruction here. So the jury was allowed to accept this evidence as for the truth of the matter, and judge accordingly. So when we get to the end of this trial, there was a lot. As the case law says, a parade of first complaint witnesses here that certainly bolstered these girls' credibility. I would argue
why do you say that it was appropriate, or at least not an abuse of discretion, for the judge to have substituted the mother in place of the children?
The Marungu, well, I submit that the judge actually didn't do the...
I know that's not what he did, but I gather you concede it would not have been an abuse of discretion for him to have done that. I
believe it's Marungu that allows for a substitution, and if in fact there's a reason that incompetency or some reason that the first complaint is not allowable, that the witness can't testify to it, or the person who first heard the complaint is no longer available. If there's yes, I agree that a substitute first complaint witness, the case law allows that.
But don't the reasons why substitution would be appropriate here go to whether or not the error was harmless?
Well, yes, and I submit, in fact, these, I don't believe that the trial attorney objected at least to the first girl's complaint, and I submit that under this analysis that there was a risk that justice miscarried here because of all the cumulative effect of all of the first complaint evidence.
But, well, I guess before we get there, on the second question, that objection with regard to the admission of what we call the first complaint of, I guess, is it TAH?
Yes,
Was that an objection to its admission, or simply an objection to whether the answer was not responsive to the question?
I think it's certainly open to interpretation, but I would argue in the end, even if it wasn't preserved, that there was a substantial risk in this case that justice miscarried, considering all of the first complaint testimony, considering both girls were allowed to support each other, not only say, I complained to my sister, but say, yeah, my sister said me too. So it's a compounding of the first complaint evidence, and added all together, I believe that justice did miscarry in this case.
But I guess, going back to the earlier point, if it were appropriate to use the mother as a substitute for the children, because at the time of the first complaint they were 7 or 8 or 10 or 11, and if the fact that they were victims means that they are not going to serve the usual purpose of a credible first complaint witness, somebody who's not a victim, who's testified to what the victim told them, wouldn't that go to whether or not there was a miscarriage of justice by the admission of that testimony?
I'm not sure I understand.
Well, the reason it's okay to substitute is because it's just not very persuasive. It doesn't serve the function of a true first complaint witness to have a 7 or 8 or 10 or 11-year-old kid saying, I was the first one to hear it, and I'm a victim myself. So you could say, well, let's get somebody who is an adult and who was not herself a victim to say what the victims told them. And my question is, doesn't that go to whether or not its admission here would rise to the level of a miscarriage of justice?
I don't believe so, Your Honor, because in the end, the judge allowed all of the testimony to come in as first complaint. So it would be a different analysis if he had said, I don't believe that these two girls should testify, that I don't believe it serves the purpose, and then disallowed their testimony if they hadn't testified. But in the end, they did all testify as to each other, and I think that changes the analysis here. And I think it adds to the unfair bolstering of their credibility. In this case, that was only about their credibility. I would also submit that even the issue of the pictures on the computer, adding that to first complaint testimony again, without evidence of a crime, that wasn't a crime, and there was no testimony when the first complaint testimony did come in, when the mother said that she questioned the girls about the touching, and when the girls said they told their mother about the touching, nobody connected the picture viewing incident that happened several days before that, even as first complaint. And I submit that that's another level of unfair evidence that came in under the rubric of first complaint that shouldn't have been allowed, or certainly shouldn't have been allowed as first complaint testimony.
And why is that not part of the context of the mother learning from the children about the allegation? I mean, otherwise it appears, without it, it appears to the jury as if suddenly on the trip to the market, the mother asked them, did this person touch you? I was totally out of the blue, if you don't understand the earlier computer incident.
That was certainly the Commonwealth's theory of the case, and the Commonwealth's theory on appeal. I don't think the evidence bore that out at trial, because none of the girls talked about that was the reason they told their mother. The mother didn't talk about that. I think in the end, it didn't. The evidence didn't support that. There was no nexus between what was happening with the computer and the pictures on the computer and when the girls actually reported this behavior to their mother.
You don't. I mean. The question does come out of the blue unless the mother, there's been something about the computer, and I mean, doesn't that explain why she would ask?
You know, I think
whether
that's
it's explicit or not?
It certainly makes sense as a theory. My argument is that it didn't actually come out in the evidence that way, and nobody made that connection, and nobody made the nexus between the two, and that
They argued that. The prosecutor didn't argue it in closing or something like that?
I don't believe so, but I can't tell you that definitively. I can tell you it did not come out in the evidence or in any of their testimony. But again, including that as first complaint, and the girls were allowed to testify to that and to all the picture taking, again, without an instruction. So once again, all of that portion of the first complaint, which again included telling the grandmother was there at that time too, and they both said, yeah, we told our grandmother, that again adds another layer to the impermissible and erroneous first complaint testimony.
Explain to me your argument on the indictment question, the question of whether or not he was convicted of a crime for which he was not indicted.
Thank you, Your Honor. The rule is an amended indictment cannot materially change the work of a grand jury. And in this case, Mr. Roby was indicted on 6, but reduced to 5 at this trial, discrete crimes. The indictments themselves say diverse dates, but the grand jury narrowed the indictment.
How did they do that?
By presenting evidence on the case of the older girl, they presented evidence of the assault in the dining room, of the assault in the Bronco, and of the assault in the movie theater. So they specifically narrowed the indictment to those facts. They did not say this is
when you say they,
the Commonwealth.
The Commonwealth. Okay.
Yes.
The grand jury heard evidence with respect to these 3 different instances,
Yes.
the movie theater, the Bronco, and the dining room.
Correct. And they never heard evidence. I believe the police officer who did the investigation testified to this at the grand jury, and they never heard evidence of an ongoing a series of events or ongoing behavior of the defendant. They heard evidence of these discrete crimes.
And so at trial, there was no evidence. The movie theater case
Was directed out at the first trial.
Because there was no evidence of any of that.
Correct.
At the first trial. Now we're at the second trial.
Right.
There was no evidence of any of this sexual misconduct in the Bronco.
No, it didn't come up at all.
But you say the indictment that alleged that, although it just said on diverse dates,
Right.
was supported by evidence of an assault in a bedroom.
Correct. Right. And I understand that place is not generally an element of the crime, of these crimes. But I submit it's simply 2 separate crimes. An assault in the Bronco in some other city or some unknown place and an assault in the bedroom are 2 distinctly different crimes. And the defendant must have adequate notice of time, place, and circumstances of the crimes. And that's what the grand jury indictment specifically narrowed these crimes down to.
So you're not relying on because the discovery also talked about those 3, right? The response of the Commonwealth to discovery also talked about those 3.
Right, right.
But if you have I guess I'm just trying to figure out, if you are right, what is it that the Commonwealth can do? You would agree that an indictment that says on diverse dates is okay, right?
Right. Date is not an element.
So what should the grand jury minutes look like in such a case?
Well, if the Commonwealth indeed was alleging a series of events or a behavior that took place if this was the kind of case where the complainant couldn't complain about a specific or discrete event with specificity, then the Commonwealth, then yes, that's what the grand jury needs to hear. In this case, the grand jury heard 3 discrete places, it's 3 discrete circumstances. And I submit that these are completely different crimes. And a test is whether or not double jeopardy would apply. If so, and I submit that if a conviction for the assault in the bedroom doesn't preclude a conviction for an assault in the car in this case.
Well, your time is up.
Thank you, Your Honor.
Good morning. May it please the Court, Catherine Semmel appearing on behalf of the Commonwealth. I'd like to address the first complaint issue first, and there are a number of elements in it, but the threshold question is concerns whether or not the judge properly exercised his discretion in allowing the mother's testimony as first complaint in this instance.
But let's assume that he did.
Yes, Your Honor.
Isn't that, I think that's conceded here.
Okay, if he correctly allowed the mother to testify as a first complaint witness, then the issue would be the admission of the girl's testimony. And I would suggest to the Court that this was not objected to on the substance, and so that first of all, it's addressed under a substantial risk of a miscarriage of justice standard. In this case, I think that there are a number of factors which are important to consider in determining whether or not there was a substantial risk. The first is the reasons why the judge, in fact, substituted the testimony or allowed the mother to testify in place of them. These are young girls. They were at most 8 to 11 years old when they made these disclosures. Even in King recently, when the Court re-examined the whole principle, they made a specific note of this particular skepticism that attaches to young children's testimony in these circumstances, that they're very susceptible to suggestion, their memories may not be perfect, and so forth. So that was one factor that the judge focused on, the young age of the girls. The other factor is that they were, in fact, both alleged victims in this case, so that the extent to which they might corroborate each other is called into question. That is, their corroboration doesn't go very far when it's their credibility that's called into question. So both of those factors, I think, are relevant in determining what the impact was of their testimony. They also testified to no details. The sum and total of the testimony was that the younger girl told the older sister what had been happening. The older sister testified that she gave her some details, didn't recount what they were, and just said that she said, "Me too," basically. So you have no details of the testimony. You don't have any repeating of the details in this case. The last factor that I think is important in determining the impact of their testimony was the corroboration that existed apart from the first complaint testimony. And the corroboration was in 2 parts. The first was the defendant's admission to the mother over the telephone when she's asking him several days later, "Why did you do this? Why did you do this?" And finally he says, "Because I wanted to be the one who showed your children how to be with a man."
May I?
Yes, Your Honor.
Your sister also referred to the fact that they were allowed to testify that they told their grandmother. Now, that came in as well.
What my sister is referring to is not the complaints regarding the touchings, but with regard to the pornography, that one of the girls testified that the grandmother was in the room when they were discussing the pornography. There is no testimony that the grandmother heard any of the substantive complaints in this case about the crimes.
But she wasn't offered also as a complaint witness.
No, she wasn't. She wasn't. The other thing that I'd like to mention that my sister referred to was TAH's reference to having discussed, having told an ADA or victim's witness advocate something. that also doesn't go to the first complaint. On cross-examination, defense counsel elicited the fact that TAH said that she had told either an ADA or the victim's witness advocate about the incident in the shed, the incident that was then struck, with an instruction from the judge that impugned the victim's credibility. I'm sorry, because this is if I can just go to that for a second, because that is another issue. The victim had testified, just a surprise to everyone, that there had been an incident in the shed where the defendant had painted a flower on her chest, and during cross-examination, the defense elicited the fact that, in fact, she's claimed to have told that to an ADA or a victim's witness advocate. When the parties ultimately decided, when the prosecutor suggested that reference, the entire reference, just be struck by the court, the judge, in fact, instructed the jurors that he was striking the evidence because none of the parties had been notified about this information, and so it couldn't be investigated or verified, and therefore that it was unfair to have it before them. So that reference as well had nothing to do with the first complaint and was in fact struck and repudiated by the court. So really, what you have is the two victims' statements about that one of them told the other one about what was happening, and the second one said, "Me too." And in the circumstances of this case, given the nature of that disclosure, given the corroborating evidence, given the lack of objection, I would suggest that there was no substantial risk of a miscarriage of justice. Does the court have any questions about the remaining issues?
What do we do with this, with the indictment issue? I mean, the grand jury was told about those three. It was not charged as a single continuing. It was not charged with one indictment as a continuing offense. And it turns out that what he was convicted of was not what the grand jury had learned of, at least as to one of them.
As to one of the incidents. That's correct, Your Honor. A couple of things with regard to that. The first is, of course, that location is not an element of the offense. The second is that I think if you just want to look at how this was presented to the grand jury in terms of deciding whether or not he was convicted of a different crime, it was certainly presented to the grand jury as the victim testifying or the victim relating to the police that at least three, and that is a quote, at least three of these penetrations occurred, and then delineating where the three were alleged to be. The indictment was for an 18-month period. There were no specific dates alleged or able to be alleged in this case. I think that the context of how this was presented to the grand jury was in the nature of a continuing offense, and that in the circumstances of this case, it did not change the work of the grand jury when it turns out that, as often happens in kid complaints of this nature, for whatever reason, she did not recall, could not testify to the Bronco incident at trial, but testified to an incident occurring in her grandmother's bedroom. And in the circumstances of this case, I do not think that it changed the work of the grand jury. And as an aside, there was a question raised as to notice, and I would just reiterate from my brief that this incident in the grandmother's bedroom was testified to at the first trial in this case. I've attached transcript references from that trial. I think my sister attached more expansive transcript references from that trial, subject to our motions to expand the record. So there was certainly no issue of notice here. The defense was well aware from the first trial, which was 5 years before this one, that in fact the victim claimed that there was an incident in her grandmother's bedroom, had ample opportunity to prepare.
The discovery that made reference to the three incidents, was that before the first trial or after the first trial?
That was before the first trial, Your Honor, and I couldn't track a paper trail as to how it came about before the first trial, that in fact there was a change, but certainly the very least counsel was well aware of it at the first trial.
What was the amended indictment? Was there an amended indictment?
No, there wasn't an amended indictment. I think what my sister was referring to was a claimed variance in the evidence at trial from that presented at the grand jury.
I want to make sure I understand exactly what you're saying. Was there anything before the grand jury, just the slightest statement that made reference to the incident for which the defendant was convicted?
The incident in the grandmother's bedroom?
Yeah.
No, the closest I can refer the court to is that the officer did say that there were at least 3 instances.
Okay, but was there a statement to the grand jury to the effect that, yeah, this has been going on in for a long time, and the 3 that I remember are these 3? Is that the way it was presented to the grand jury?
Well, the victim didn't testify. It was through the police officer. And I don't think there was anything more expansive. Certainly the grand jurors knew that it was a diverse state 18-month indictment. I don't believe there was any reference to the repeated nature or the more expansive nature of the allegations as to this victim, except for the term "at least."
And is there a conflict between charging a continuing violation and charging 3 indictments? I mean, generally, when you do a continuing violation, it's 1 indictment charging a continuing series of events. Here you charge 3 indictments, each charging a continuing series of events.
Well, I think that they were representative indictments. I mean, they were representative instances of the crime, and no, I don't think it's a conflict. I think there are different ways to charge cases such as these, and we often will pick out representative charges when there's an ongoing offense like this at trial.
Didn't he get sentences that were, I mean, it matters in this case, doesn't it?
The charge that's at issue here, the charge in the bedroom, was actually one of the charges for which he received a concurrent term of probation. It was not the consecutive sentence. The consecutive sentence that was imposed in this case was was delineated as a dining room offense when the charge was presented to the jury.
Was it clear to the grand jury that the continuing offense included, or the continuing nature of the offense included more than the 3 specific offenses that were presented to them?
I think only to the extent that the term "at least" was used. I don't think there was any more explicit explanation to the jury about how extensive the abuse was beyond that. There are no further questions.
All right,
That's my brief. Thank you very much.
We'll take a brief recess.
All right.